issued a preliminary injunction blocking a Mississippi law that protects children from online predators. The injunction rests on serious errors of law. This court should reverse, and it should stay the injunction as well. As the court knows, our brief addresses several issues, several errors the district court made. This afternoon, I want to make sure to address two: standing and the First Amendment. If I may, I'll begin with standing. On standing, the dispute before this court is whether NetChoice can assert the First Amendment rights of its members' third-party users. The answer is no, and that knocks out much, if not all, of the injunction in this case. As we've explained, a plaintiff cannot assert a third party's rights when the plaintiff and third party have a stark conflict of interests. That's Kowalski at page 130, that's Joseph H. Munson at page 958, and that's Newdow at 15, 17, 18, all cases from the United States Supreme Court. Here, there is a stark conflict of interest between NetChoice members and those members' users. In short, Your Honor, what NetChoice is trying to do is it is acting as the wolf speaking for the sheep. We would not let the wolf guard the sheep. We should not let the wolf speak for the sheep. NetChoice has a very powerful interest in opposing any governmental regulation of social media platforms. Their interest, quite powerfully, is to argue that any law regulating a social media platform categorically intrudes on the First Amendment rights and faces strict scrutiny. We see that in their papers today. Anything that affects access to online platforms, strict scrutiny. That is not the interest that users share. Users have an interest in First Amendment rights, of course. They also have a strong interest in their own online safety. They have an interest in not being sex trafficked, extorted, or exploited. Their interest is to argue that laws can regulate social media platforms without violating the First Amendment, and that strict scrutiny does not automatically apply, and in fact, that rational basis review applies to some regulations. In short, the judiciary, this court, the district court, no court can rely on NetChoice to represent users' interests. And for that reason alone, NetChoice should never have been allowed to press the First Amendment rights of users. That error pervades every part of the district court's injunctive analysis, and it requires vacator. Now, we've run through that in many ways in our brief. I am happy to largely rest on that. I would just emphasize that in granting NetChoice the ability to assert users' rights, no court has squarely considered this obvious conflict of interest problem. It has blown past it, if it has addressed it at all. Those courts, those decisions are not persuasive whatsoever. I would also add, my friend Mr. Keller has said that these conflict of interest principles do not apply in the First Amendment context. That is surely wrong. Joseph H. Munson itself, the Supreme Court assured itself at page 958 of that decision that there was not a conflict of interests. There's also no good reason not to apply this conflict of interest analysis. It's pretty intuitive. When you look at prudential standing, any court's desire to hear a well-presented case where you hear the full adversary presentation on all sides, you do not want the only party you are hearing from on one side of the case to be beset by a conflict of interest.
What do you do about the fact that I'm sure must be true, that there are consumers for which you are right and there are consumers for which you are wrong, that NetChoice and the consumer completely agree on the interest?
Well, I think the court would want to hear from at least the consumers that we're right about. It's I think quite intuitive, Judge Ho, that there are such consumers, and there are such consumers that, again, by NetChoice lights.
Put simply, you've got to make it real simple. There are consumers who like your law. There are consumers who dislike your law. You're here to represent those who like the law, since you're obviously representing the law itself.
Well, we don't know that there are consumers that don't like our law, Your Honor. According to NetChoice itself, this law covers many, many websites well beyond NetChoice membership, we have not been sued by consumers. And if NetChoice is right about this law, it would cut off the First Amendment rights of many, many people. The most cherished rights of all to many people. If that were really true, then I would think we would see at least some users saying, hey, we don't like this, and here's why. We haven't seen it. The injunction here protects NetChoice members. It does not reach what NetChoice, Mr. Sabo in his declaration has described as the many other websites that's covered by this law. So again, it's an intuitive point. This is very much not like sort of a bookstore-bookseller relationship. Again, people are not showing up in bookstores to be sex trafficked in kind of any reasonable normal case. That, Virginia versus American Booksellers, very different case for that obvious reason. I do think it's notable that no decision in the multitude of social media law cases we're now seeing, no decision by any court has been able to explain this problem. We do ask the court to do so, and on that ground alone, the court can, as I said before, knock out the entirety of the injunction. And I would just close this point by noting, in the first sentence of NetChoice's paragraph 1 of its complaint, in the first sentence of its preliminary injunction briefing, it invokes the rights of users. This is the most important part of its case. Without that, it has a piddling case. And speaking of that, I will now turn, if I may, to the merits. Now, on the merits, I do want to address both the facial issue and the merits analysis. Of course, the facial applies to all the claims, but I just want to hammer this home, and it's something that we, of course, have pointed to in our 28J letter filed last week about this court's recent decision in Paxton. The Supreme Court's decision in Moody and this court's recent decision in Paxton make quite clear that the injunction here cannot stand. I mean, those cases show that there is a staggering burden on a plaintiff bringing a facial challenge, particularly in the humongous social media internet world. And there is nothing, the plaintiff has a burden to come forward with evidence showing every hypothetical application, was the words of this court in Paxton, every hypothetical application of the challenge law to everyone covered by the challenge law.
So that turns on our understanding of the First Amendment, right?
Well, I think I think of that step one, it's just turning on what the law requires of and who it requires of people. I think the First Amendment is kind of the next step, Judge Ho. But I think it's, as the court put it in Moody, at I believe 2398 to 99.
I mean, we wouldn't need to remand if it was obvious that given the law at stake here, which is a different kind of law than these other cases, if the law here were theoretically unconstitutional in all applications,
I mean,
we wouldn't need a remand, right?
Essentially
what NetChoice is arguing in its counter.
It is.
I'm not saying that's right or wrong. I'm just
right. No, I mean, that's surely their argument, Judge.
You have to talk about the First Amendment to understand the vacator point.
Sure, Your Honor. So
that's all I'm saying.
Yeah. So I guess what I'm saying, the way I see step one is, as I believe the Moody case put for the court, to even do the First Amendment analysis, you have to know what the state law covers, what it does, what it requires. And in a facial case, you have to know what it requires of everyone. So, what would somebody have to do under the law? What are commercially reasonable efforts for every platform to commercially reasonable efforts to verify age, obtain parental consent, all those kinds of things? That could be a very different question across platforms, and NetChoice has never presented evidence as to what that's like. And that's severely problematic. I mean, as Paxton makes clear, and this gets, I think, perhaps to Mr. Keller's kind of most direct point. Mr. Keller kind of says, look, Moody was worried about, do we know what services are covered? Are there other actors? And his position is basically, here we know it's interactive social media platforms, and that's enough. Moody and Paxton are quite clear that that's not enough. It's not just who is covered. It's what would the law require of them? At pages 498 to 499, and I believe 500 of the Paxton decision, this court is not just saying, what are the platforms that are covered? It has a lot of how questions. How does it affect this kind of service? How does it affect that kind of a service? And applying those questions here, you would ask again, what is going to be required of the Instagrams of the world or the Facebooks of the world, both of which, according to Instagram and Facebook, already do age verification on some services on their platforms without requiring IDs. That could be a very different question than, say, some other platforms. But we have to know those things.
Would a platform like LinkedIn be covered?
I don't think so, because I think it would fall under the career services or the kind of career opportunities exception.
So, certainly the Act applies to digital services where users are socially interacting. Doesn't apply where the primary function is, I guess, career development. LinkedIn arguably, straddles a bit. People post, they interact for the purpose of career development. So I'm not sure if that's covered or not.
So I think, Your Honor, I think LinkedIn falls in a different exception. I think you're referring to the one about allowing chat functionality incidental to. I think it's the next provision, sub D, that refers to just sites that primarily function to offer career development opportunities. And I think that's kind of recognizing that LinkedIn is basically, it does have a lot of chat functions, but they're all kind of presumptively in the pursuit of career development opportunities. They're not kind of interactive encounters where minors are being exploited.
Well, I guess the big picture question in the background is if the act applies to social interaction but not professional interaction, does that make it content-based?
So two answers in response to that, Your Honor, and you're anticipating the point I wanted to get on the merits point, so I will hit that hard. One is there is no kind of distinction between social, people chatting and professional. What socially interact is getting at is, when we read a book, we are interacting with literature. I mean, Justice Scalia kind of points that out in the Brown decision. Socially interact is it's communicating with other people. It's not just going online and kind of reading somebody else's blog. It's communication between two or more users. That's what socially interact means. So it could be professional, it could be otherwise, but it's the communication, it's the interactivity where children can be exposed to predators who can then exploit them. Now, to get to the content-based point, Judge Willett, there's been a lot of focus in this case and similar cases on the coverage definition, what it does, and that kind of gets the very most basic First Amendment question wrong. I mean, the most basic question in a First Amendment case is, does the First Amendment apply at all? And the First Amendment and First Amendment scrutiny is not triggered by laws that just regulate non-expressive conduct. And requiring someone to take reasonable steps to verify age, obtain parental consent, or mitigate known real-world harms, there's nothing expressive or inherently expressive about those things. So whatever might be said about the coverage definition, the operative provisions are about conduct and non-expressive conduct. And to bring it back to just the facial analysis, my friend Mr. Keller has never shown otherwise, because he's never shown that these provisions, one, on their face, they do not affect anybody's expressive choices. Now, he has claimed that they affect access to these platforms, but he's also never shown that because his showing on that requires on obvious misreadings of the statute. I mean, just to run through the three kind of key ones. Age verification, this requirement that government IDs are required, not true. Parental consent provision, the idea that you need to verify the parental relationship and that you need family law expertise to do that, not true. Strategy provision, the idea that that requires monitoring and blocking content, not true. The Act requires none of those things. It requires commercially reasonable steps to make non-expressive physical actions. An analogy I would draw the court to would be a bar. We all know that, a typical bar, we know that there's certain conduct that occurs in there, presumably the consumption of alcohol. There's also a lot of speech that occurs in many bars. People talk about things, some light things, but also political things, deeper things in life. Protected speech. Bars host both. Under Mr. Keller's theory of this case, imposing an age verification on a bar would have to face strict scrutiny because it would affect access to speech. I respectfully submit that is ridiculous. Now, my friend would come back and say, hey, but the whole point of these social media platforms is to engage in speech. Also not true. I mean, look at Mr. Keller's own declarations. Pages 87 to 96 of the Szabo Declaration run through some of these content moderation policies that exist precisely because of the horrible conduct and harms that happen on these platforms. Drug sales, child sexual abuse material, human sex trafficking, these kinds of things. So yes, although these companies host some speech, they also host large amounts of non-expressive, unprotected conduct. And the fact that we have regulated the conduct, we are allowed to do that, and I think there's a stark difference as a result between this case and, say, the kind of marquee cases that my friend cites. I mean, look at Reno, Ashcroft, Brown. All of those they were regulations of speech. Reno, barred transmitting or displaying certain messages to minor. Ashcroft, barred posting online content. Brown, barred selling or renting video games to minors. They were regulations of speech.
Do you have anything more to add on the idea of pushing pause or remanding to the district court for a redo of the Moody analysis? Anything beyond your briefing you want to say about that?
Sure, Your Honor. I would say this. Surely there needs to be a redo. I think I would take the cue of the Moody decision itself, where the court said, look, this analysis needs to be redone, but if we just send it back without more guidance, there's going to be a problem. The district court's going to kind of repeat the errors. So I think the court does have to speak to, hey, look, on its face, these provisions are regulations of non-expressive conduct.
In your view, what additional factual development is needed? I mean, unlike NetChoice v. Paxton, is there any real dispute here what actors and activities are covered?
There is, Your Honor. I mean, again, there's a dispute over what each person would have to do under these statutes. What is the commercially, I mean, again, the submission of Mr. Keller has been, age verification will require people to submit government IDs. That is not true. And he should have to come forth with evidence that says, okay, here is what is a commercially available method for Facebook and Instagram, who apparently already do age verification. Here's what's commercially reasonable for all these non-members. Here's what's commercially reasonable for those other folks. He's never come forward, his client has never come forward with evidence showing what people actually have to do to comply, the how.
So how much discovery has occurred so far, and what more do you think would be necessary?
None so far, Your Honor. I think, we have the declarations in this case, and we emphasize, I apologize, I'm over my time, Your Honor, but I think, first of all, we'd have to know, after this court clarifies that the facial analysis just wasn't right, we have to see, are they going to keep this facial analysis thing going? As Justice Barrett observed in Moody, it may not even be possible to bring a successful facial challenge in this kind of context. So that would be thing one. I think thing two is they would have to present evidence for all of the other non-member platforms, in addition to their member platforms, about what do they do? What can they do? What would be commercially required? What would that account for? If they're using an age verification system that, like one that's apparently in use now where somebody just has to wave their hand a few times in front of a camera, doesn't have to, give any identifying information, how would that, how easy would that be? Would that just take a second? Would that dissuade a single user of that platform at all? Those are the factually intense questions. I think, just to close out the point, recognizing my time, Your Honor, I think the Paxton remand opinion was just very clear that there has to be extensive work. But again, that's on NetChoice. We did not force it to bring a facial challenge. It chose to do that. It has to meet its burden.
You were in the middle, it's okay.
No, good.
You were in the middle of sort of suggesting the instructions that would be appropriate for this case. Obviously, each case deals with different contexts. Do you want to finish?
Sure, Your Honor. So I think it's a little bit similar to the Ninth Circuit's recognition in NetChoice versus Bonta on age estimation, where it says, look, on its face, there's nothing about this age estimation provision that affects expressive conduct. So we remand to kind of redo this analysis, recognizing that some of these things on their face do not affect anybody's expressive conduct at all. And if their theory is some access theory, they have to provide evidence on that. They can't just, and they have to do it in a way that would satisfy the facial standard for everyone across the board, not just sort of a pick and choose. This might happen on DreamWith, but we're not going to tell you what would happen on Facebook or on Instagram. It's an awesome burden. So I think clarify that, look, on its face, this seems like a regulation of non-expressive conduct. The district court was wrong to recognize to the contrary. And just, we've laid out our view of how it should be in your brief. But I would say that it's more than just kind of crediting, vacate, redo the analysis. It's offering some guidance on the merits issues as well, including vagueness, preemption, that sort of thing.
Okay.
Preemption if the court were to breach preemption.
Okay.
Thank you, Your Honor.
Stewart, thank you. We'll see you back on rebuttal. Mr. Keller, welcome. Good afternoon.
Good afternoon, Your Honors. May it please the court. I would submit what you just heard from my friend, the Solicitor General, was a sweeping assertion of governmental power. The Supreme Court in Brown said that laws like these, quote, do not enforce parental authority over minors' speech. They impose governmental authority, but the state lacks power to prevent minors from hearing or saying anything without their parents' prior consent. And we know from Brown, from Reno, from Ashcroft, that strict scrutiny applies when the government tries to age-gate speech. That's exactly what this Mississippi law does. Now, there are many points that I'd like to touch on if possible. We heard about standing. We heard about the facial challenge framework. We obviously have Brown on parental consent. We have Reno and Ashcroft on age verification, and, of course, the monitoring and censorship provisions. I will try to take them in that order. First, starting with standing. On page 28 of their brief, they concede that we have associational standing to raise claims on behalf of our members, the websites. That alone means there's Article III jurisdiction. So the laws here burden the website's ability to disseminate, to distribute protected speech. And make no mistake, These social media platforms disseminate an immense amount of protected speech. We know that from Packingham and, of course, Moody. I mean, everything from football highlights to cat videos to jokes to political rallies to religious speech. This idea that this is somehow a targeted law about sextortion is not true. And in fact, Mississippi in the same legislative session passed a separate law directly criminalizing that abhorrent conduct of sextortion. And so whether we're talking about a less restrictive means of directly regulating the bad conduct, or Mississippi could give parents additional information about all the parental tools that parents have to control minors' experiences online at the device level, the network level, and the software level. The websites here, like in Brown, have voluntarily taken industry efforts to address the problems that Mississippi's sweeping law seeks to do through content moderation. So our members, the websites, their First Amendment rights themselves are being violated. We win this case on that basis alone. Now, we do submit that we also can raise our users' rights under American Booksellers Association. That was a case involving a trade association. The Supreme Court recognized standing for users' rights to be adjudicated because in the First Amendment, and this is American Booksellers, quoting the J.H. Munson case that you heard quoted by my friend, the statute's very existence may cause others not before the court to refrain from constitutionally protected speech or expression. That's precisely what we have here. Because parental consent under Brown is unlawful, age verification for all sorts of protected speech is an immense burden to access speech. And you heard my friend say that, well, it's burdens versus outright bans. The Supreme Court has already rejected that distinction in Sorrell and in Playboy. The Sorrell case said government content-based burdens must satisfy the same rigorous scrutiny as its content-based bans. So restrictions or burdens on speech equally trigger First Amendment scrutiny. If I could turn to the Moody facial challenge framework, because I know there's been multiple questions about that. First of all, there is no Moody facial challenge error or violation or any additional record that would be needed for this court to assess the constitutional analysis of this facial challenge for two main reasons. First of all, there's no argument that the constitutional analysis might differ between different actors or activities, between different websites or functions. And here, we all agree about the Act scope covering social media platforms. It excludes email, online marketplaces, payment services, events management, ride-sharing services, all of those other categories of websites that Moody said maybe a different First Amendment analysis would apply when it comes to compelled speech. The defendant has not argued otherwise. Any argument to that effect is at this point forfeited. And so this is all about social media platforms. And the issue in Moody, what Moody said was, well, the court there didn't necessarily potentially address the full range of activities for other kinds of websites beyond social media platforms. But here the district court did that analysis. What I hear my friend to be saying is that the commercially reasonable language of the statute makes some sort of difference. And Judge Ho, I agree that that really goes to the legal duty. That goes to the duty imposed. That doesn't go to the actors or activities covered. That is, social media platforms, digital services providing for users to socially interact. And we turn to that constitutional analysis. Judge Willett, this is a content-based law. LinkedIn being excluded because of the professional speech aspects, but it's not just that. News, sports, or entertainment websites, those are excluded. That is as content-based as it gets. And so we can have a debate over whether social interaction is content-based or not. We think it is. We understand there's a dispute about that. But I think it doesn't matter. This is still a content-based regulation based on the coverage definition excluding news, sports, commerce, entertainment, and professional speech. And we haven't even started talking about the Section 6 monitoring and censorship provisions, which of course are content-based themselves.
So what do you ask us court to do? What do you ask us to do?
I would ask you to affirm the preliminary injunction. The preliminary injunction rests on sound findings that this does regulate speech. And make no mistake about that. Under Packingham and Reno and Ashcroft and Brown, when the government tries to age-gate protected speech, it triggers strict scrutiny, it implicates the First Amendment. This is not just conduct, and I think their argument proves way too much. I mean, it would allow the government to impose age verification or parental consent to buy books or buy movie tickets, or even their argument about, well, please create a strategy so that you will prevent or mitigate these categories of speech. I mean, I don't think anyone would tolerate government being able to go to a newspaper or a TV station and say, we don't like these categories of speech, so please prevent or mitigate those.
What would a constitutional age gating parental consent statute look like?
I'm not sure, Judge Willett. First of all, what I would want to know is what is the government's interest and how tailored is it to that interest? I mean, in Brown, that was a case where that was both age gating and parental consent. Footnote 3 of Brown said that the government does not have the power to require stores selling video games to ask for prior parental consent before minors could consume speech. And when it comes to age verification, and I know this court had the Free Speech Coalition case regarding more targeted towards pornography websites that's on review at the U.S. Supreme Court. Maybe in a case like that with a different interest and a different tailoring, it could be, a different phenomenon. But when we're talking about age gating millions, if not billions, of aspects of protected speech, the government, I'm not sure could ever come up with a valid, tailored law.
Yeah, that's what I thought you were going to say, is there is no such law in response to Judge Willett.
Yeah, and Judge Ho, I mean, I don't want to stand here and give a categorical, in
Isn't that your reading of Brown?
Brown?
I'm not saying I agree or disagree with it, but isn't that your reading of Brown, essentially?
I mean, Brown's holding says that the government cannot just age gate and prevent access to speech. Now, if we weren't talking about something like access to speech, if we were talking about some other law, and I'm sorry to speak in these hypotheticals, and of course this is not this case, but when we're talking about what could the government do, I think it would have to do something far short of what it's doing here, which is preventing access from speech and restricting speech. And that comes back to our arguments about all the less restrictive means that are available here. I mean, Playboy itself said what governments can do is provide information so that their parents and here parents would be able to use all the tools available that the industry has made. And it's devices, it's software, it's everything in between. And Mississippi, of course, has passed other laws directly regulating the bad conduct at issue. And as we know from Barnecki and Packingham, that is a less restrictive means rather than a sweeping speech restriction that would limit access, restrict access to protected speech.
You want to respond to the state's bar hypothetical or analogy?
Yeah, I think when it comes to physical access and associational rights, Stanglin's on that side of the line. But I mean, this court's precedent, this would be Club Retro in Kennedy. It says when there is a communicative content and there is elements of expression, the First Amendment, of course, is triggered. And here, when we're talking about engaging in speech on social media websites, we're not talking about physical access to places of congregation and association. What we're talking about is speech among individuals that are going and posting for many people to see. That is core expressive activity. We know that from Packingham and Moody. We also know that from Reno.
Why do you draw this distinction? If I understand you correctly, it's a bar is a physical place, whereas this is the internet. Why is that the line?
Well, I think it means because the internet is so clearly.
Is it because there's nothing else but expressive conduct on the internet? Is that essentially what we're saying? You don't drink alcohols, online.
Judge Ho, what Reno said, the Supreme Court said that states can't cyber zone the internet by imposing restrictions on speech and trying to use this idea that, well, this is something akin to a zoning ordinance. And so I think Stanglin in the zoning ordinance cases, whether it's a secondary effects doctrine or it's the secondary effects doctrine or Stanglin, are completely distinguishable. And Reno, almost 30 years ago now, said they don't apply. If I can turn to the Section 6 monitoring and censorship provisions, I think in some ways, the litigation over this has taken a different path to the point that now what I hear defendants saying is that this provision, does very little. And I would suggest then that I'm not sure it furthers the government's interest. When we started litigating this, we were focused on that this law requires adopting and implementing a strategy to prevent or mitigate exposure to a list of categories of speech that are not at all confined to historically unprotected categories of speech. And now what I hear from my friend in their reply brief is some version of, well, you could satisfy this if you just published a list of resources for people online. Well, if that's the case, there's an obvious less restrictive alternative, and that would be the government itself can publish that list, just like the government itself could provide information to parents saying, here are all the various tools that you have to control and monitor your minors' online experiences. And so we would submit that this is requiring a speech policy in advance. A social media platform to disseminate speech has to come up with a speech policy that is preventing or mitigating the various categories of speech. And these categories of speech cover all sorts of protected speech. Promoting or facilitating things such as suicidal behavior. I mean, that's Peter Singer. Practical ethics, it's Romeo and Juliet. I mean, other things like promoting harassment. I mean, think about what that could cover. I mean, if someone on a social media platform takes a screenshot of someone's speech and sends it to a bunch of their friends or otherwise posts something saying, hey, can you believe that that person's a Trump supporter? Tell them what you think about that. Was that promoting harassment? Incitement of violence, that's another category that's not at all confined to the Brandenburg test. Facilitating or promoting other illegal activity. I mean, that would cover things such as someone saying, hey, let's go violate curfew if curfew is illegal in that community. So this is to say that all of these examples are far beyond any of the narrow categories that the Supreme Court has articulated of being unprotected speech, which is all to say this law is all about age gating and restricting protected speech. Billions of pieces of protected speech. And so when I hear the argument about, well, maybe this is just conduct, or maybe this is not.
Of course, the Supreme Court said in Ginsburg that when it comes to minors, that it's a different ballgame, that you really can, insofar as the parents control, that they don't enjoy the same level of protection as the First Amendment, under the First Amendment. That's sort of a background principle. I don't know how it plays out here. As I understand this particular provision, it's not. It reaches much further than that. It's just narrowing to the individual.
Yeah, Judge Higginbotham, I'd point you to Brown, because Brown said, yes, what Ginsburg says is, well, the state does, at a high level of generality, have an interest in protecting minors, but what it does not include is a free-floating power to restrict the ideas to which minors may be exposed, and of course the law has to be tailored to
That argument was made in the Supreme Court recently, and the Supreme Court said that we need to reconsider all this, that the world has changed, et cetera, in terms of electronics.
Well, at the risk of reading the tea leaves into a pending U.S. Supreme Court case, which I would not pretend or try to predict how it would come out, what I would say was, however that case comes out, and however
the focus was on Ginsburg, which gave the state a great deal of latitude
regarding pornography.
Regulate, and now the court is plainly rethinking the whole phenomenon as to because of the digital world and its movement.
Well, but Ginsburg itself too, and Free Speech Coalition, of course, were laws largely about pornography. Here, we're talking about so much more. And so, but even I would also submit, even if the court were to say something that maybe backs off of Reno and Ashcroft a little bit, and again, we don't know that, that is a far cry from a law like this when you're talking about age verification for adults and minors to access all sorts of protected speech. Also, to come back to our initial argument, this law too is content-based because it includes news and sports, entertainment, and professional speech. So that alone too would trigger strict scrutiny. So, at any point in the analysis, I think we have pretty good arguments that this law triggers strict scrutiny all the way down and in every instance. If I could address my friend's statement about parental consent and age verification and what this law does, I think there's a bit of a straw man being attacked here, because the parental consent provision, regardless of whether you have to verify the parental-child relationship, this law requires parental consent.
So what should we do? What do you ask us to do?
You should affirm the preliminary injunction. The district court got this right. The district court got right that we have standing. The district court got right that this law is unconstitutional, even if not in all applications, substantially outweighs whatever possible hypothetical applications where a law like this could potentially be constitutional. That applies to the age verification provision under Reno and Ashcroft, the parental consent provision under Brown, and the monitoring and censorship provisions.
If a mom has a blog, she allows some comments. Nobody else can post, but she allows comments. Her primary purpose is just to share her own life updates or whatever she cares about. That website would not be a covered, tell me if I'm wrong, would not be a covered digital service provider under the Act and would not be age-gated. Is that right?
Well, I think what the court would want to think about is that a digital service provider that connects users in a manner that allows users to socially interact with other users on a digital service and allows a user to create or post content that can be viewed by other users of the service. Now, we'd have to then consider also the exclusions. Is it news, sports, entertainment, commerce? I'm talking this out loud, of course, because there hasn't been any dispute about the actors and activities covered by this. But
my question was going to be, so mom has a blog, she talks about her life, people maybe post comments on it. I didn't think that would be covered, but if she posted the very same exact verbatim content on Facebook, it would be covered. And
that's certainly true. And I guess, Judge Willett, I don't mean to be obtuse, but I think I'm hanging up a little bit on precisely what the posting content and the comments section would be. But regardless, whichever way that cuts, though, if that's excluded, I think that only helps our content-based argument. If that's included, I think that only shows an additional burden on speech and a restriction on speech from this law.
But doesn't it at least show that we should vacate and rebound? You may or may not win or not in the district court, but this suggests that there are actual disputes, notwithstanding the prior briefing.
Well, I don't think that it is about the full range of the statute. And in particularly when you take then, what is the full range of the statute, and then what are the constitutional principles? If I understood the hypothetical there.
But this is not a hypothetical, right? There are a lot of blogs like this. This is very commonplace, and if we don't know if they're covered, this sounds like exactly what the Supreme Court was saying in Moody.
Well, Judge, first of all, the hypothetical raised is at this point, that has never been an argument that the defendant has made. They have forfeited any argument that somehow that anything beyond
you mentioned forfeiture before. What do you mean by forfeiture? The district court didn't have this decision.
Well, even on appeal, even in their appellate brief, they have not made an argument that somehow there are more websites beyond social media covered. They say that this is clear, that this has a focus on that, and we've agreed. If there's any distinction there, it's far too late to raise that particular argument. Also, too, we're at a preliminary injunction phase. Of course, this is not the end of this case, and we'd ask Judge Higginbotham to affirm this preliminary injunction. If there's any issues that they want to raise going forward in the case, I would submit that they can do that with the preliminary injunction in place, and we can continue litigating.
is there anything to be gained by waiting for the Supreme Court to decide Free Speech Coalition?
I don't think you'd need to, because I think we would still win even if Free Speech Coalition were to recognize a different set of principles for pornography websites. At the same time, again, this court, of course, can manage its own docket appropriately.
One of the frustrations of this is that while the Supreme Court has this case, what's happening is that there's a trial judge, a very able trial judge, whom this case is pending, and there's no opportunity for an actual trial to go forward where you can get on ready to open court to exactly what the dimensions are. This doesn't have any immediate impact on this case, to my mind. But one of the frustrations is that there's a whole world out there as to the ability to monitor and do these things, various things, and that factually have never been developed, because they took that case off a preliminary injunction and not going back before the trial judge.
Well,
but neither here nor there.
And Judge Higginbotham, but I can tell you, in this case, we have factual record. This is at ROA 137. This is the declaration from the Next Door experience, where they actually tried to do age verification in some form, and users reported that it was just totally insane. It was a scam.
I don't see any real fact issues underlying this case. I mean, it's a sweeping requirement, and
Yeah, we agree. I was just merely pointing out that we have record evidence that confirms exactly what Reno and Ashcroft said, which is that age verification is a significant burden on accessing speech.
Okay, Mr. Keller, thank you very much.
Thank you.
Mr. Stewart, you're batting cleanup today with 4 minutes.
Thank you, Judge Willett. I'll try to do my best to make 2 or 3 points. First, I think, Judge Ho, your colloquy with Mr. Keller does affirm that at the very least there has to be vacator here. I mean, we have never forfeited this. We have hammered the burden on a facial standard throughout this case and underlined at every turn NetChoice's failure to meet that standard, and we have, especially in the wake of Moody and Paxson, made very, very...
You're saying you haven't made this particular argument.
Yeah, he's just saying, we have not identified the one, hypothetical user.
Oh, he's saying that you have not disputed the scope of platforms that are at issue.
We haven't.
The universe of regulated parties.
I mean, we don't disagree that it applies to interactive social media platforms, but if that's all Moody required, then it wouldn't have had to vacate this court's decision in Paxton. I mean, the first sentence of that opinion recognized that the law covered large social media platforms. It's a much, much, much deeper discovery-laden dive than that. On number 2, I think I have a point that I think ties together a lot of what I'd like to say in response to Mr. Keller. He mentions Brown and Reno and Ashcroft and these other cases. As I endeavored to hit home when I was first up here, all of those were on their face regulations of speech. They said you can't transmit, you can't post this content. And then after that, there were regulations based on the content of speech. That is the key fork in the road difference from those laws and the law here. Requiring age verification, just as, the bar example, Mr. Keller had no good response to that, even though the analog is very much spot on.
Well, I think his argument was pretty decent. He's saying that there are a lot of things that happen in bars. The only thing that happens on the internet is speech.
That's just flat wrong. I mean, Judge Ho. I mean, we know that.
What else happens then?
Child sex trafficking, drug sales, child sexual abuse material, exploitation of minors, incitement to suicide, sextortion, like all of these horrible, horrible things. And I think one thing that Moody is, starting to make clear is that you don't get a pass for your bad conduct that you host just because you take it on the internet. And this idea that all social media platforms do is host wonderful First Amendment protection speech, that it's just educational videos on YouTube, is wholly implausible and clearly out of step with Moody itself. Mr. Keller mentioned this idea, there's no difference between burdens and bans. He cited the Playboy case for that. That's page 812. That is true when there is a content-based regulation of speech. And that's why it's different here. I mean, think of things like general taxation, visiting hours at prisons, visiting hours at bars. These things all affect access and ability to engage in speech. They are not regulations of speech, and therefore they don't face strict scrutiny. They face normal, just everyday, non-heightened scrutiny. That's what we're asking for here, and it's appropriate because, again, age verification, parental consent, harm mitigation, they are all regulations of conduct. They're not telling...
Can we go back to the bar discussion?
Yes, Your Honor.
I'll admit that's where I'm sort of stuck. You mentioned that obviously the internet can lead to a lot of horrendous criminal activities. Fair enough. I share the concern. Those things don't actually happen on the internet. We're talking about communications that lead to it.
I mean, I think
that's what you're talking about.
Communications where people are trading photos and then making threats through words. I mean, you can call that communications. That doesn't make them.
Is your idea that those communications themselves are not protected speech, or is that you can regulate? Is this a not speech claim, or is it a government interest claim? You see where I'm going?
I think it is either non-speech or conduct or unprotected. Like, say, I will pay you X amount of money for these drugs. It is wired to you. Send the drugs to me, or send me this.
Crime facilitating speech and therefore unprotected.
Yeah, for example. I mean, but again, it's this idea that everybody's just logging into these platforms to do nothing but speech is wrong. And just as we would be able to make regulations based on a physical establishment's status, no matter what speech they host, we should be able to do so here. I see that my time is up.
Life would be easier under Justice Thomas's dissent, wouldn't it?
Well,
it's just not the law is the problem.
You could probably say that in a number of areas of law, Judge Ho, but I'm happy to go with the majority here. Thank you.
All right, we'll end on that note. Thank you, Mr. Stewart. Appreciate the arguments of counsel, and the case is submitted, and we're going to stand in recess until 1 p.m. tomorrow afternoon.